Hello, you are listening to the Divorce University online podcast with your hosts, Thomas and Tammy Ferreira.
Hi, I'm Tammy.
And I'm Thomas.
And we are back. And today we're going to talk about motions. Now, in California, this is called a request for order. They're order to show cause, they're called sometimes. But generally, it's a motion, which essentially means you're asking the court to make an order on something.
Right.
Whatever that is. And I mean, we're going to kind of use child custody as an example because I think that's the most common one that we see. But really, this can be about, support or the family home or a business or paying bills or whatever you want it to be about.
So, Tammy, why don't I do this? I'll give some context for this.
Okay.
So when we're getting a divorce, the court has to make decisions on parenting plans and division of assets and support and so forth. And to do that, you've got to get to the end of the process somehow. So there's in every state, virtually, although I only practice in California, disclaimer,
Right.
See a local professional, disclaimer.
Right.
When you've got a situation where you're trying to split up the parties, it doesn't happen overnight. It can't happen overnight.
Right.
The court has to make orders that preserve the status quo or the way things are right now until the litigation's over.
Right.
So the court has to make issues on property, which means...
You mean orders. You said issues.
Did I say issues?
Yeah, you said the court has to make issues.
The court has to issue orders.
Right. I knew what you meant.
So, thank you. I always have her with me so make sure I don't make any mistakes.
Yeah.
So the purpose of the motion most of the time, there's all kinds of reasons for motions, but the main thing is to protect the status quo, protect the children, protect the income of the parties and the assets until the case is over. And that can be anywhere from 6 months to 4 years,
right?
Depending on how much conflict you have.
Yeah, depending on how much you want to fight about it.
Right. So we go in and we have these motions. And when I file a motion, normally I am asking the court to make an order on behalf of my client for child support, for spousal support, child custody and visitation, and attorney fees. I mean, those are kind of the big four.
And it could be either just one of those or any combination of those or whatever, depending on the situation and the strategy and all that stuff.
Right. Like, for example, if my client doesn't want to pay support and he's the higher earner, then maybe I don't want to raise spousal support. I'll let them do it.
Right. Right. Or if I'm mom and I've got the kids and dad's only seeing them a few hours a week, then I probably don't want to file a motion because he's probably not going to get any less than that.
Yes, probably not. Probably going to get more.
Unless I want him to take the kids more. If I have teenagers, I want to get rid of them. I'm going to file a motion so he has to take them.
Yeah. And they call the request for order process in California the workhorse of the court. A lot of the important decisions are made in the case because when you get temporary orders, they tend to become permanent.
Right. They tend to carry through to the end of the case.
And they may be modified some, but they what they do is they establish where the ballpark is.
Right.
So what's the range that this case is going to be resolved in?
Right.
And so they are important. And the frustrating thing about it is that in the courts where I practice, a request for order hearing is normally a 20-minute hearing.
Right.
You can ask for a longer hearing, but usually that's where you need some testimony. You need some live testimony with court reporters and witness stands and all that stuff. But the vast majority of them are set, 11, 10, 12 cases on a typical morning calendar. And you see request for order, request for order, request for order, request for order. And what's amazing to me is how efficient the experienced judges are in getting through that calendar.
Yeah. And from the time that you file it, it's only from the time you file it, you're usually looking at about 3 months, at least in California. I mean, depending on
Yeah.
every court is different and the volume is different. We're in San Diego, obviously, a lot of people, a lot high volume, all that kind of stuff. But whatever, court you're in, they're going to set the hearing date out from when you file it. And so usually you have procedural timelines to comply with, like, when we file a motion in, here in California, we have to serve it at least 16 court days before the hearing,
Right.
So,
Which means you don't count the weekends and holidays.
yeah,
Right.
yeah. You have, and yes, you have to know your holidays and count it all out and make sure that you're,
What if it falls on a Saturday?
yeah, well, I'm not going to get into all those gory details, but
Right.
if your 16th day falls on a Saturday, then you're counting it wrong, because
Well, it means
it
you
doesn't
go,
include weekend and holidays. You got to
Yeah.
go back one more day.
no, you go forward one more day.
Well, you go back. If your 16th day is a Saturday, before
Oh,
that, you
I
go
see.
back to the Friday.
Oh, you
the
mean
Friday would be the 16th
in terms of
day.
when you have to serve the
Yes.
motion.
Yes, but
Right.
that gets confusing, I think, when we
Right.
start talking
So-
into that level. But
Yeah, we're gonna assume that the basic, how to, where the business office is and all that kind of thing. And what I want to talk about in the podcast is some strategic considerations when you go through these motions.
although I am going to try to fill in some of the nuts and bolts from a paralegal perspective. as
She's the
you're- as you're moving
paralegal.
along.
She has half the brain. That's why we're together, because Tammy is a good administrator and I'm kind of, the creative one.
Right.
But here are some strategic points. Number one, you got to consider that the court's overwhelmed.
Right.
It's just overwhelming, because what happens is they have, I think it's typical for them to have 8 or 9 RFO cases on a morning's calendar. And in order to, what you don't see the court doing is they take these files home, or I guess now they look at them electronically,
Right.
and they read the pleading, they read the exhibits and the pleadings and everything, and they make what's called a tentative ruling. And that's how they usually do it. I've seen, there are some judges that kind of have a reputation for doing it more on the fly, and some are able to do that. I could not do that. Most of them are going to read that file about a week in advance.
Yeah, and some counties in California do issue their tentative.
Mm-hmm.
So every county kind of has a little bit different procedural. You really got to go read your rules of court,
Right.
so that you know procedurally how your court handles it.
Right. And so normally, if you have an experienced judge, that judge has read your file and has an idea of where they want to go with the case.
Mhm.
So your first line of defense really is the written portion. Okay. And what I see, particularly self-represented people do, is they don't really know the law. They don't know what they're talking about. And so they think, well, I'm just going to throw up all the facts I can think of and hope that something sticks.
Yes, very common strategy.
Yeah. And the problem with that strategy is that it makes it hard for the court to understand what's going on. You've got a very short, they don't have time to read this more than once.
Right.
So you have to hit the high points.
Right.
And it would be a good idea to learn, look at some of our podcasts, look at some of our material on Divorce University Online, and try to understand what the court is looking for in these hearings.
Right.
For example, in child custody, they're looking for, first of all, safety. So they want to make sure that the child's safe, that they're being clothed, fed, and educated. Yeah. And then beyond that, what they're really concerned about is whether the child's exposed to conflict in the relationship,
Right.
and whether the parents support one another and cooperate.
Right.
And so if you know that, that's how you craft your argument. You craft it around the priorities. You're looking at it from the point of view of the judge, and that judge has to decide, well, how am I going to keep these children protected and help these parents develop a cooperative co-parenting plan for the rest of these children's lives.
Yeah, and you know what's interesting? I think in the last couple weeks here, I've had at least 3 or 4 people that I can think of that have asked you a question along the lines of, should I settle or should I negotiate with the other side on this issue, or should I just go forward with my request for order? And our answer to that is always, 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 yes, you should try to negotiate.
Well, not always.
Well, I
always.
mean, I think
that's
you should
3 alwayses.
I think you should try. Almost always you should try. What do you have to lose by trying? Now, by saying negotiate, I don't mean you're always going to settle. I'm not saying that, or you're always going to roll over and give the other side whatever they want. That's not the same thing.
Well, you're assuming that the issue that in the case is not adequacy. It's not this child. I'm not here on an ex parte hearing, an emergency hearing, and seeking full custody because.
Correct. I'm assuming like nobody's driving drunk with the child in the car, and nobody's beating the child, or nobody's using drugs in front of the child, or But even in those circumstances, I think that you can try to negotiate. Like if you have somebody who's afraid of, let's say, alcohol use. Let's say there's heavy alcohol use and you're afraid of that. You're worried about the other parent using alcohol. Well, that doesn't mean you can't try to negotiate an outcome. Maybe your outcome for negotiation is that it includes random drug tests, or it includes a breathalyzer, or it includes, now will the other parent agree to that? Maybe, maybe not, whatever. But all I'm trying to say is I think people...
You should negotiate more than people think you should.
Right.
Which is not the same as saying always, 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 always.
Well, I mean, I say that because people almost always think that, I'll just let the court decide. I mean, how many times do we hear somebody say, I'll just let the court decide?
That's not what I'm saying.
Okay.
There are times when you have to take the fight, and we, as mediators and as coaches, we have relationships with aggressive attorneys that we refer people to when it's time for them to fight.
That's true. But I mean, what you had said before I said that was that, assuming that the safety issues are not a concern.
Right.
So assuming the safety issues are not a concern, I'm just saying that really there's no downside to at least having a discussion with the other side and seeing if you can come to some agreements. There's no downside to attempting that.
Right. I agree.
That's what I mean.
I agree with that. But you really should establish your position as a position of strength with solid pleadings. And what I find that people do is they give the court too much to read.
Yeah.
Because they're afraid they're going to miss something.
Right.
And that's not a good thing. I write this booklet that we offer on Divorce University about writing declarations. And the central theme of it is your declaration has to have a through line. It's got to have a central point that you keep coming back to.
Right.
And once you've established that through line, you can organize your arguments around bullet points. The mother is talking negative to the child about me, and I'm concerned that the child's relationship will be alienated from me.
Right.
I'm concerned that point number 2, the mother doesn't cooperate with me by transitioning the kid into clothes. She puts ratty clothes on him for me, and she takes my good clothes. And we see that conflict sometimes. And 3, but you want to bullet point it and then give a couple of examples for each one.
Right.
Because it's a 20-minute hearing.
Right. Right.
And half of that time is the other parties.
Yeah, I was going to say, and of that 20 minutes, you only, excuse me, I sneezed. I don't normally do that in the middle of a podcast, but of the 20 minutes, half of that yours and half of that's the other side. So really you have 10 minutes, and then the judge usually has some remarks in there, and so really you got 5 to 7 minutes to present your side. And that's why it's important that the written part be very concise, easy to read. I mean, Thomas talks about newspaper headlines and dividing it up and numbering your paragraphs and, all those kinds of little logistical things that are just going to make it easier for the judge to get through.
Right. Because basically what you're trying for in that writing is you're trying to win the tentative.
Right.
So you have your exhibits that, some courts have you lodge them separately, and then they give them back to you at the end of the hearing. Some courts have you attach them to the request for order. But either way, if you give them too much to read, they're going to stop listening. You ever have a document you're trying to read and you get to the end of the document and realize that you were thinking about what you're going to have for dinner that night?
Yeah.
That's what you want to avoid, right?
Yeah.
You want to make your document compelling and you want to get to the point. You want to summarize.
Right. And you want to hold their attention.
And hold their attention. Right.
Right. And if you're droning on and on about the 15 different aspects of the other person's parenting that you think are a problem,
Right.
then, you've already lost their attention. And so going back to what Thomas said earlier, you want to have only like 3 or 4 key points, and you want those points to line up with what the law is. And I find that's the biggest challenge for, if you're self-represented, the biggest challenge I always say is learning the law. Right? If you have an attorney, the biggest challenge for your attorney is learning your case.
Correct.
And so it depends on which
That's
side.
good. I like that. That's a separate podcast right there.
It depends on which side of the coin you're on. But if you're self-represented and you're trying to learn the law, then, you want to go out and research, if it's on custody, research best interest of the children, read through it, figure out what is it that the court is focused on. And that way you can, make sure that your 3 to 4 key points tie into those things that are listed in your best interest of the children statute. A lot of times people get really hooked onto that best interest of the child buzzword, especially in custody situations, and they'll start doing things like they'll end every sentence I think this is in the children's best interest.
Right.
And it's like just slapping that label on it is not
right.
That doesn't make it so.
That's not persuasive.
Right. And so you have to really give concrete reasons why, this is, the conflict is harmful. The child's struggling in school. The child's therapist says there are concerns, blah, blah, whatever your things are, they need to be concrete things and not just something that you've, randomly put this label on.
Right.
And I would say by the same token, I mean, let's say that you're going to do an RFO, a request for order of motion on, let's just take spousal support. Well, in California, that's governed by Family Code Section 4320. So there's like a dozen or so.
4320?
Yeah. The spousal support factors, 4320.
Oh,
right?
Spousal support factors. I'm sorry.
So,
I didn't hear you correctly.
Yeah. So
right.
if you Google that and you read through that, it'll give you the dozen factors that the court's considering on a permanent order. So on a permanent order, if you're writing a declaration, you want to make sure that it's lining up with those key factors. Now, a lot of times a request for order is only for a temporary order, and that's a little bit different issue. But then you Google temporary spousal support in California and you figure out what are the factors that go into that. And so whatever issue that you're doing in your RFO, there are code sections of law in your state that will outline for you exactly what the court is compelled to consider for that particular topic.
Right. And that's a good thing if you're not a great writer, and not everybody is. That's a good place to go to an attorney and get some limited scope help to ghostwrite your pleadings. In California, you don't have to tell the other side that your pleadings are ghostwritten. So you can get very attorney-like pleadings that are over your signature by hiring somebody to do that, and we do that as well.
Yeah.
But the other thing I want to talk with the time we have left is appearing in court. And appearing in court is for people who have never done it. It can be nerve-wracking.
Very.
Yeah. It
I
really,
find just sitting there watching you was nerve-wracking for me for a long time.
right. And I remember my first few hearings. It was, I was really frightened because you got the judge up there, and you got the court report, and everything is so formal, and you got your notes, and oh gosh, what if I forget something, and blah blah blah.
Yeah, I've seen times where you and I are sitting observing, and you'll see the attorney's hands shaking as they're,
Yeah.
as they're flipping their pages or whatever. I've observed that multiple times with all kinds of different attorneys.
Right. Well, and I'm not saying this to make you afraid,
Right.
because here's the thing: this judge wants to do the right thing in your case.
Yeah.
They want you to have enough money to support yourself. They don't want to bankrupt the other part, the paying spouse. They want your kids to have continuing meaningful time with both their parents. They want certain outcomes, and the trick is to try and filter your whole argument through the eyes of what the court's trying to accomplish. For support, if it's child support, it's a guideline, formulaic type thing. So the court is really looking for the data to put in the support calculator.
Right.
They want to know how much you earn. How much does your spouse earn? If you've got self-employment, what is your net income before taxes,
Right.
and that kind of thing.
And every state has different formulas.
Has different, the different what we call child support guidelines. And if it's child custody, really that court wants to protect the child from abuse,
Right.
And more commonly to protect that child from conflict between their divorcing parents.
Right.
So it's kind of weird. It's like that George Costanza thing where you try to do the opposite of what you should do. It's counterintuitive.
Seinfeld, for all you young people that don't know who George Costanza is.
Yeah,
but-
everybody knows who George Costanza is.
I bet not. You ask your son who's George Costanza, he doesn't know.
Yeah.
Of course, he doesn't have any kids yet, thankfully. So
That's right. Well, the thing, it's counterintuitive in the sense that if you come into court and you're very negative about the other party and you attack, that's a good way to screw up the case.
Right.
You want to be perceived by the court as being cooperative and being willing to find solutions to problems.
Yeah, it's weird because I find that's very counterintuitive, especially in custody cases. It's like, people sort of think if they can make the other parent look as bad as possible, that they're going to get the upper hand on the parenting time. But actually what the court wants is for the child to have both parents in their lives. So the parent that is showing the court that they're willing to do things to ensure the other parent's relationship with the child, that actually gives you the bigger advantage.
That's absolutely correct. And oh gosh, I lost my train of thought. Say something smart.
Yeah, I mean, I just find that a lot of the court stuff is counterintuitive, and it like Thomas said, it can be really nerve-wracking because you got this, the judge sitting up there on their high,
I call it the days.
the
Yes.
days. Yeah, that's the
word of the
technical
day.
of it. But one of the
Yeah.
things that we always tell people is, go watch on a day that it's not your case, so that you don't have those nerves and you don't have that going on, and you can observe what's really happening, and you can observe the judge's reaction to different arguments in different types of cases and all that type of stuff.
Right. And a lot of times it's better to be positive about yourself than negative about the other party.
Right.
So, tell the court about your relationship with the child. Tell the court that you're warm, that you have a warm relationship, that you spend time together, that you help with homework, that you read bedtime stories.
Yep.
That kind of stuff. In a way, you're trying to get the court to go, oh, she's a really good mom, or this guy's a really good dad,
Right.
really involved, really stepping up to the plate. And if you're positive about yourself, it usually it'll carry more weight than being negative about the other party.
Right.
And,
Right.
I mean, sometimes you have to tell them, look, this person's a falling down drunk. And
Right.
and I think that I think that the court should have a substance abuse evaluation.
Yeah, I mean, sometimes that's the situation. But, even when that's the concern, you don't want to paint it as this person's a horrible, awful person because you don't want to label it as a falling down drunk.
Right.
You want to say, I'm concerned about the child's safety because, from having lived with this parent, I know that they tend to drink,
Yeah.
6 to 12 beers a night. And
And then
I'm
there's
concerned that the child.
Then there's the
will-
2 DUIs. and-
Right,
yeah.
right. You want to give your facts. You don't want to say, oh, well, this person's just a horrible, irresponsible, lazy drunk.
Right.
That's not persuasive.
That's a good point, Tammy. And yeah, I think my concern is, or as a parent, I'm concerned.
Right.
I love the word concerned when I'm arguing custody cases.
Right.
My client is concerned that the child's not safe in the father's care because of his drinking.
Right.
He's been, he's fallen off the wagon a few times, and you can give some background and some examples.
And, if you're the other parent in that situation, like let's say your dad and mom's accusing you of that, or your mom and dad's accusing you of, mental illness or drug use or whatever. What I find, and we've had this happen particularly with people who have alcohol issues, moms and dads, we've seen this to where, if the person is defensive about it and like, well, I never do that. And, they're just lying. And then you have all this, they have, evidence to the contrary. What happens is you just totally kill your credibility with the court because
That's true.
I
I've
mean,
seen that
Thomas had
happen.
this experience like many, many years ago. We talk about this case where the guy got on the stand and swore up and down that he didn't drink. And then the wife, who was self-represented, by the way, pulls out this big picture off Facebook of him holding this huge bottle of vodka with his arm around another woman. So she had a key piece of evidence that totally destroyed his credibility on the stand.
I
And
hate when that happens.
yeah, especially when you don't know it's coming, right? And that person would have been way better off to say, I do sometimes, drink and party or whatever, even, when I don't have the kids.
I wouldn't use the word party.
No, maybe not. But I'm just saying, I do occasionally drink socially.
I drink socially.
And
Glass of wine, a martini. at
hang out
dinner.
with friends and socialize and drink, when I don't have the child, but I've never drunk in front of the child. I don't drink during my parenting time. I'm not an alcoholic. I don't, I have a steady job. It hasn't caused me work
I am
problems.
not an alcoholic.
Yeah. I mean, I'm just saying, like, whatever it is. And if you are an alcoholic or you think that that's what the court's going to think, then you say, then you get into AA and you say, I'm in AA and here's what I'm doing. And, we've had clients that say, here's my chip, here's my 6-month chip, or here's my,
Yep.
whatever. And the court doesn't expect us to be perfect. The court expects us to take responsibility for whatever is
Right.
going on in our life. And that's really what they want to see. They don't go, oh, you have a diagnosis as an alcoholic, so you can never see your kids again. Like, that's not the deal. The deal is, are you an active alcoholic or are you in recovery? And if you're in recovery, you have as much opportunity to have time with your children as the other parent.
Yeah. So with the time we have left, I have a tip.
We have as much time left as you want to take.
Right.
We could do a 2-hour podcast if we wanted to. I mean, they may turn us off, but we could just keep
Nah,
going.
don't do that. That's my way of saying this should be the last point.
Okay.
Okay. So this is something that attorneys learn the hard way, and every one of them does. Okay. If you're winning, stop talking. If you're winning, stop talking. Okay? Because, well, it's in my notes. I have to say it. No, you don't. If you're winning, stop talking. So what I see happen all the time is that people volunteer helpfully facts that, the court goes, oh, well, then I think that you need to pay more support or something like that.
Yeah, it goes against you.
It goes against you. So my experience is that normally the person that the court wants to hear from the most is the person they're getting ready to rule against. Like, if you have a tentative, you already know what the tentative is, but the court has has made a tentative ruling, and what they want to do is question the party they're getting ready to rule against, to test that and make sure that that's the right order. Okay. So if you're the person that's not the beneficiary of the tentative, then that's your chance to point out things that the court might not have considered. That's your chance to turn it around. And you certainly want to answer the court questions as much as possible. But if the court is not addressing you, I mean, normally the moving party goes first.
Right. Whoever filed the motion.
Whoever filed the motion goes first, and then the other person goes second, and then the moving party gets another chance at the end to do what's called a rebuttal. But a lot of times, with certain judges like Torres in North County, he usually cuts to the chase. He just says, what I'm concerned about in this case, I've got this speech that I've written, right? I come to court and he says, I'm really concerned about the child's ride to school. So I want to hear about that. And, be ready to.
Yeah. So you just cut the rest of your speech and you only go with that section.
Right.
Which was hopefully in your speech.
Yeah. Well, but if the court is spending a lot of time with the other party, it's not necessary for you to get your whole thing into the record.
Mm-hmm.
Stop talking.
You know what's interesting? I'm going to tack onto that because I have had more than one coaching client that says something like this. I think I might need to change attorneys. Well, why is that? Well, because I don't know. I didn't feel like court went that well. I don't know. I feel like it's the points aren't being made. And then I say, oh, okay. Well, what didn't they say that you wanted them to say? Well, they didn't bring up that, dad's late a lot for the pickups, or they didn't bring up that, mom never returns my clothes, or whatever the little thing is. There's usually 2 or 3 little kind of more emotional type things like that most of the time. And then my question a lot of times is, well, what did the judge order after that hearing? And I remember one in particular, the mom said to me, oh, I have 70% custody.
Right. Got everything I wanted.
And I said, so you got a good outcome? Well, yeah, I got a good outcome. And you're thinking you might need to change attorneys? Why?
Right.
And so I helped that person kind of back up and go, that's emotional. That's emotional because I don't feel like the attorney said everything that I wanted them to say for me to feel heard by this judge.
Right.
But I got what I wanted. And so what I said to her is, your attorney knew what to say and what not to say to get the outcome that you wanted to get.
Absolutely. Tammy. That's
ultimately where you have to focus is, did I get the outcome? And honestly, a lot of times if you didn't get the outcome, it can be traced a lot of times back to your own behavior. And that's a totally separate podcast. We've done a lot of podcasts around that topic, so you can go search and find more. But
this is not therapy.
Right.
This is not therapy.
The judge is not there to hear you.
You want to feel heard, join Tammy's support group.
Yeah, or yours.
Or my
if
support
you're a
if you're the
dad,
guy,
right. Right. But,
Yeah.
and that's what that's for is, to help you understand, it's a lot of what Thomas do in our coaching, helping people understand what's happening in court, how to approach court, how to handle things, how to recognize your emotional feelings versus what's tangibly needing to happen in the court system and all that kind of stuff. And our emotions very much interfere. A lot of times if I talk about emotions with the coaching, people are like, oh, I don't want help with that. Well, what you don't understand is that's overlapping with what you're trying to accomplish in court, and it's causing issues. You got to deal with the emotional component of it in order to be able to succeed in the legal side of it.
Right.
And that's the advantage of having the attorney, right? Is that they're not emotional. That's what you're paying them for. You're paying them to get the result. You're not paying them to make you feel better.
But if you're a and this is not
self-represented,
this is like a little bit of a deviation. I said the last one was the last point, but just remember that the court wants to do the right thing by your kids, and the court wants to make the right decision.
Right.
And you might sound nervous. You might not remember all of your lines and everything you want to say, but the court is really wanting you to succeed and tell them what they need to make the right ruling in the case, and you can do this.
Right.
You can do. I remember the first few times I did it. I got through it.
Yeah.
And you will too.
You will survive. Yes. All right. So thanks for joining us. If you are watching us on YouTube, don't forget to hit like and then subscribe to our channel so you get notified as new videos are released each week. If you're listening to the podcast, please rate and review us and also subscribe. Helps increase our rankings, helps other people find us, and helps us help others. So thanks for joining us.
Thank you so much.
Thank you for listening to the Divorce University online podcast with your hosts, Thomas and Tammy Ferreira. For more information, visit www.divorceuniversityonline.com.